It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like, how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my willing co-host, Brett.
Hi, Alice. That was so professional the way you did that.
That was Tina, who is in our chat right now. Thank you, Tina, for saving me as my brain synapses were not connecting, and I couldn't think of a word to describe you because, Brett, frankly, you are indescribable.
That works. Like Bigfoot or, something horrible that cannot be described.
Well, you are a willing co-host because, man, okay, y'all, Brett is like above and beyond everything you think he is in a positive way. He is. You guys, do you know how dedicated he's been to this trial? This man is living and breathing the Murdaugh trial, the Murdaugh trial, the Murdaugh trial. Who knows how we say it?
Enough
For
of
your sake.
Alec. For your sake.
Actually, I wish we could do a poll here. What people want us to call it. I almost feel like we need to I'm going to take Alec and you take Alex, or like you take Murdaugh and I take Murdaugh.
I'm sticking to Alec. Alec is my.
But it's
and I like
spelled
Murdaugh
Alex.
better than
It's
Murdoch.
spelled Alex, though.
Or Murdoch. Or Murdoch. It's just like an slight, an easy
just,
sort of CH at the end. It's very difficult.
Just like a murder.
Murder. That works too. Murder.
Alec murders.
Alec. Alleged murder.
We might be giving away too much in this intro. Well, you guys, all jokes aside, I mean, we're so happy to be here with our wonderful patrons in this live recording. And Brett has brought the federal, what is that? The
Federal Criminal Code and rules.
And look how big it is. Turn it to its side. Guys, you thought the Bible was big. I mean, these are like rice paper thin pages. I'm not saying it's the Bible. I'm just saying this gives you a little view into the criminal justice system. And this is just the federal one. This doesn't include all of the states. Lots of rules, lots of codes, lots of elements, lots of cross-references. And this is all we're going to read through.
We're going to read the entire book.
We are here for your questions. We will talk about it. Just so you guys know, you're not going to get shortchanged on the trial. That will be, a 20-part series. Mm-hmm. But tonight, we are close in time to the court making the decision to let in 404B, other acts evidence, about the financial crimes that Murdaugh is alleged to have committed. And I don't know what Brett's doing over there. I think he's doing it for show, but that is a big deal. And you've probably seen a lot of clickbait about it. Like, oh, this is either so unfair, this is correct, or what does money have to do with this? His other crimes will be tried for those if he chooses to go to trial. This is a murder trial, and we're here for a murder trial. What does this have to do with the money? So we are here to talk all about that and to answer your questions. And I am talking really fast. I feel like I've maybe I don't know.
Alice was up all night. Not last night, but the night before. That's the thing about the law. Sometimes you have to stay up all night to do your job. And she was doing it. We recorded last night. She was on 0 hours of sleep. So that one's going to be fun.
That one is, Jason, those outtakes are going to be amazing.
And then we're back today. And we're doing for those of you who it's not obvious when you hear this on the podcast, this is a live recording with our patrons who've joined us for this, which is always fun. We enjoy that. It's one of the great things about Legal Briefs. We do a lot of these live recordings. And as Alice said, we are going to do a deep dive on the Murdaugh case. We've already started recording it, as a matter of fact. And who knows, we may finish our 8th episode by the time they finish the trial at this rate. You never know. Maybe, who knows? You may have heard all the episodes before they finish the trial at this rate. This has been,
it's kind of a race in a way, like how fast we can record and how slow they can go.
Yeah. Well, they can go pretty slow is the answer. I know a lot of you, we talk about this some in the other episodes we're going to do, but I know a lot of you have been watching this and have commented on just how slow this has gone. And that's not what we're talking about today. We're talking about Rule 404. It's really a huge part of this case. If you've been following this, if you've watched it in real time, you know there was an entire mini trial about that. We're going to talk about that some too. Some people thought that was surprising or weird or unusual or problematic, and in fact, it's not. It's actually pretty common. But all of this was about whether or not these other acts' evidence was going to come in this case. And I'm going to read you, I have in my hands the federal rules of evidence and the code, which Rule 404 in South Carolina is basically exactly the same. So that's why we have this fancy book here. But Rule 404A, we're going to talk about 404B here in a second. But Rule 404A, character evidence, other crimes, wrongs, or acts. Number 1, A1, prohibited uses. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or character trait. And what you often see here is essentially we're not going to allow general attacks on your character to prove that you did something wrong. But it goes further than that. 404B, prohibited uses. Evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with the character. So you see, we have this general rule against using your character to convince you. This is the round up the usual suspects rule. We're not going to say, well, there's been a crime committed. Let's find all the criminals. It was probably one of them. And we'll use the fact that they're a criminal to prove they committed this crime. But it goes beyond that. You can't use prior crimes or prior bad acts to show their character to then show they acted in accordance with that character. And this is confusing to ordinary people because we do this all the time. In your life, you do this all the time. If you know someone who has lied to other people, you're less likely to believe them when they talk to you because you think they've lied before, they're likely to have lied now. But despite the fact that you do that in your life, generally speaking, we don't allow that in criminal cases.
A real life example is a lot of you, before you buy something or use someone's services, you might go to, say, Google reviews, or before you listen to our podcast, you might look at Apple reviews. And based on what other people have to say about us, you determine something about us and whether to proceed with us. We do this all the time because we live in a cohesive, complex world where our characters and our acts are not siphoned off from the rest of life. But as what Brett just read to you, the law does treat those other acts as completely siphoned off from the charges that are brought before you that you are tried for at that time. And that's why, by the way, you can be charged under multiple different complaints or indictments for different acts. Because you've probably heard in this case that Murdaugh is facing, 90, almost 100. Yeah, close to 100 different indictments. Why isn't it one? If they are different acts, you typically don't tie all different bad things that people do together.
And a good example of this, those of you who paid close attention to the Kristen Smart case, You may recall that the prosecution in that case attempted to charge him not only with the murder of Kristen Smart, but also with some sexual assaults of other people. And at some point, the court said, we're not going to allow that. We're going to sever these cases. You got to try the murder over here, and you'll try the sexual assault over here. And the reason's pretty obvious, because very difficult for the jury to separate those two things if they're not closely related. And what you're trying to avoid here is you're trying to avoid the jury saying to itself, let's take the Kristen Smart case because it's the most sort of visceral. And Alice she uses this as an example. Rape is really visceral. And so you could imagine the jury's like, well, I'm absolutely convinced he's a rapist. And frankly, I don't really care if I have reasonable doubt about him committing the murder. I'm going to say he's guilty for everything because this guy never should get out. You know, I mean, it's sort of that other crime overcoming the jury's ability to consider reasonable doubt, and you don't want that. You want people to be found guilty based on the evidence of the crime itself, not on bias, really. I mean, that's the fear is you're going to bias the jury against the defendant in an unfair way, and so we want to avoid that by keeping that kind of evidence out.
But. Aha! What is Murdaugh being tried for right now? Murder. Not the other murder. Not the other almost 100 financial crimes. And already I'm seeing kind of like a Christmas tree pop up with lights of comments over here. But he hasn't been convicted of those financial crimes. It hasn't been proven. All good questions. And this is exactly what kind of the media has seized on. And there's a lot of misinformation there. Because what is 404B actually saying, Brett?
Well, that was 404B1. And the thing about the rules of evidence is they always sound absolute. And then there will be massive exceptions that you can drive a truck through. We've talked about this with hearsay before. You know, if you want to flip over, if you want to take your rules of evidence book that I know you all have out with you, and flip over to Rule 800, just a few, pages away, you'll see that hearsay also has a very broad rule. And it says, the rule against hearsay. Hearsay is not admissible. Okay, that's pretty definitive. Unless any of the following provides otherwise, including these rules. So that's Rule 802. And then Rule 803 begins the parade of exceptions to that very strict rule that you don't allow hearsay. Same thing with 404. So 404B1 tells you you cannot use evidence of other wrongs in a trial. But what you have to do is you have to go to 404B2. And then we get into the permitted uses. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Those are a lot of examples. And note,
a lot of examples.
Those are not all-inclusive. Those are just some examples of what you can use Rule 404 to show. So those are a lot of exceptions. And so I think the question is, when do those exceptions come into play?
Absolutely. And obviously we've given you all the reasons why 404 evidence is not allowed in, because we don't want you to make up your mind about the character of a person based on their other acts. With these exceptions, no, it doesn't say you should, it's supposed to say you shouldn't use those acts if let in for one of these myriad of exceptions to go to the character of the person to then show their guilt in this instance. But we are human beings who may be instructed to act and think of things a certain way, but it is very difficult for us to completely separate motive from, say, bad acts, meaning he is more likely than not to have committed this bad act that he's being tried for.
And 404 is interesting because you think of it upon your first reading as a rule of exclusion, that it's excluding certain types of evidence from consideration. But in fact, legal scholars and courts have noted that it is not a rule of exclusion. It's a rule of inclusion. It's actually telling you when you can use evidence you wouldn't otherwise be able to use. So think about it this way. There's a phrase in the law, you may have heard it in this case, called res gestae. And what that's talking about is all of the matters, all of the events, all of the evidence surrounding the crime itself. So there's the crime itself, and obviously all the evidence at the crime scene involving the crime, that's clearly going to be admissible. But res gestae is a little bit broader. It's sort of telling the whole story of the murder. It's why what you ate that morning for breakfast might come in, even though you didn't kill anybody until that evening. It's part of the res gestae. So there's that. All of the little things that might have happened that help tell the story, that's all going to be included. There's been some discussion about that in this case. We'll talk about how in a second. The other thing are these Rule 404 things, and they are events that are not directly related to the crime, but that you can build a bridge between the events and the crime itself. And if you can do that, if you can build a bridge and connect it using one of these reasons or another good reason, then the evidence will come in. And generally speaking, the courts are pretty broad about what they allow in if you can show one of these aspects. In this case, obviously, motive is the main thing. The prosecution doesn't have to prove motive. We all know that. But motive, as evidenced by the fact it's included in the rule, is something everyone acknowledges is important and is something that the jury often wants to hear about. And in cases where motive is particularly important, the urgency to get in motive evidence will be even higher. In this case, what do you have? This is not a random killing. This is not, at least the accusation is not, this is a random killing. If somebody's driving around shooting out of their car at random houses, what they're thinking and their motive and why they would do such a thing actually isn't that important. But when you're accusing a father of killing his son and his wife and then attempting to cover it up, then motive becomes very, very important. And the prosecution has pointed out how important motive is, and the defense, in its own way, has confirmed that. The defense has said things like, this was a loving family man. He loved his family. Paul was the apple of his eye. He had a perfect marriage with Maggie. They have asked witnesses things like, can you think of any reason he would do something like this? And when they do that, on the one hand, they're doing something called opening the door, which is when you as the defense say something that allows something in that wouldn't otherwise come in. But another thing they're doing is they are highlighting how important motive really is. And how do we know it's important? Because it's something they themselves are focusing on. And that really strengthens the prosecution's argument that the jury needs to know exactly what the motive might have been, what the things were that were going on around this murder that might have led to the killing.
Something Brett just said is really important for understanding the back and forth here. You apply these rules per case. There is not some perfect scientific, code or equation that lets you know when it's proper to let in 404. But Brett just said if the defense is opening the door to this type of testimony, it's fair to allow the prosecution to rebut this character evidence, this bolstering of who Murdaugh is, right? It's about fairness here. The defense doesn't just get to say, what a great, upstanding family man this person is, without the prosecution basically being able to poke holes into it. And so that's a risky thing for prosecution, because obviously that's a very powerful argument to make, and one you would think you'd want to make. It's hard for any of us, I think, to understand what would drive someone who seems to have status and money and power it seems to love, his family, to one day snap seemingly within a matter of like an hour and brutally murder his son and his wife. And so by them telling that story, and the court acknowledging that they're opening the door, and the prosecution gets to tell the full story. Remember, it's not one-sided. That's why there's advocacy. There are two sides of the V. You can't tell the whole story without the financial crimes. That's the prosecution's argument for why it should be let in, even though this is not a financial crimes trial.
And let's be clear here. There's no question the prosecution's right about this. If he killed Maggie and Paul, it was because of the financial things that were going on with him that were being uncovered on that day. There's no question about that. He did not kill them for some other reason. If he is guilty, that is why. And that makes it even more powerful that it would come in. This is not speculative in the way this kind of stuff can be.
I want you to press on that because a couple people have already asked this. They've said the financial crimes, it doesn't seem to come in that day. It doesn't seem to have come to a head that day. So those people who haven't been following the trial closely, which you probably have lives and are not watching 12 hours of, jury trial a day. Brett, can you lay out why it is coming to a head that day?
Yes, absolutely. So the way this all happened, Murdaugh, Duck, had been stealing from his clients and stealing from his law firm since 2011. This was a long-going fraud, millions of dollars that he was stealing. And the first time that this came to a head was after the so-called boat case. Those of you who know nothing about this case, Paul, who was his son, who was one of the people who was murdered, was involved in a boating accident in which he was very, very, very drunk and almost certainly driving, and one of his friends was killed. And Paul and his father, most importantly, were being sued by the family for wrongful death. As part of that, and we've heard this from the plaintiff's attorney who represented the family, they had made certain demands on Murdaugh about his financials. They wanted to find his money. The problem for Alec was, despite the fact he had been stealing a lot of money and had been earning a lot of money, he'd also spent it way beyond any ability. It's a really good question about where that money went. But in any event, he doesn't apparently have the money. And this pressure is coming on him to open his books and show this. He is now going to his law firm and asking for them to structure money coming in so that it doesn't appear to be his, so it won't be the subject of this litigation. His law firm's like, yeah, we're not going to do that because that's illegal and unethical as well. At the same time, and in fact, on the very day that this happened, the law firm realized that a check in almost $800,000, I think it was like $792,000, Murdaugh had put it directly into his account rather than putting it into the firm. The way it's supposed to work is you win money, it goes into the firm, and then the money is divided amongst the partnership at the end of the year. That very day, he had been confronted about that by one of the bookkeepers in the law firm. Also that day, his father, who was someone who had loaned him a lot of money and had sort of been his financial backup, goes in the hospital and is not expected to live. So you have this sort of perfect storm gathering around him on this day where everything is starting to fall apart. He doesn't have any money and he doesn't have any time. And essentially the theory of the prosecution is Murdaugh, knowing about the $700,000, but also knowing about the millions more that would come out if people continue to look into this, decided that the only thing he could do, and I actually have a different theory that once we do this, I will reveal. But for now, we'll continue with the prosecution's theory. The only thing he could do was kill his family to essentially buy himself some time. And it worked. The law firm stopped looking into it. The plaintiff's attorney in the boat case said, based on that, we would have dropped him as a defendant. There was no way a man whose family has just been killed, no jury is going to give you money. So he was going to be out of that altogether. So it almost would have worked had it not been for the fact he had stolen so much money that in September, literally somebody picked up a file off his desk that they needed and a check fell out. And when they looked at the check, they realized it wasn't just a $792,000. It was a lot more money that he was putting into his own account, which led to him being fired, which, oh, by the way, when that happened, what happened immediately afterwards? On the roadside, he was shot by an assassin. And as the prosecution pointed out, when, I think he said, when Hannibal's at the gates, violence happens with Alex Murdaugh. And so in two different instances, when he is faced with his financial ruin, what happens? One, his family gets killed, and then he gets shot by a supposed assassin. And the prosecution theory is all of this is the motive. It is what caused him to commit these acts.
Thank you, Brett. That was beautiful. That was amazing. Note, because I'm already seeing people be like, but I don't buy it. I don't buy that he's going to blow his son's brains out to buy himself some more time. We are not actually talking about whether that was his motive and whether that actually happened in his mind. What we are saying is whether that is enough to allow this type of evidence in under 404B to show motive. So those are two separate questions. Now, whether that's the best story to win for the prosecution, whether that's actually what happened, we may have some other theories and we can talk about that. But what we're trying to show here is that there is a story to be told to understand what the motive was that may have driven this man to do something completely just unthinkable for 99.9% of the rest of us. And that was what the prosecution laid out. I'm not sure I would have laid it out quite like that, but you can see the argument, and the prosecution is right. But that falls squarely within the rules of allowing in other acts to show motive. Whether that's a good motive is another question.
And that's 100% right. And I feel like everybody misses this when they talk about this. It doesn't matter whether you buy it. That's not the question. The question is it admissible? Should it have come in? It obviously should have. There is no question that this is admissible.
And that's the point, right? Admissibility just says, does the jury get to hear it? Because it's the jury's job to decide and weigh the evidence to decide if they believe it. And that's where we're missing the disconnect, and we're trying to separate those two. The rules are about whether it can be even presented at all. So it's like I can present two different things to eat to my child, and they can choose to eat it or not. Just because I present them broccoli does not mean they will eat it at all. He makes a decision. The jury makes the decision whether to pick up on that motive. But the decision of whether to present the broccoli is what we're talking about here. And that's what 404B is. It is just a gatekeeper of admissibility. The weighing of it is up to the jury. And that's why the jury is a black box. We don't know what they'll think. A lot of you have differing ideas on whether you think that's a good motive or not. That's exactly right. But it's whether you should be allowed to hear that as the jury to consider the motive.
And two things. Number one, somebody said they understand why the June 7th stuff comes in, but they're not sure about the other stuff. The June 7th stuff, the judge said, and I think he's probably right, is res gestae. It's not even 404B. It's part of the case itself. That he learns that morning, he calls his wife and tells her, you need to come home, and then his wife and his kid are dead that night. That's not even 404B. Everything else is 404B. All the other financial stuff is 404B, and it all goes to motive, and that's why it's going to come in. Now, look, judges have a lot of discretion. I was actually kind of surprised that the judge just let it all in. I thought the judge actually would limit it more, maybe not to just the June 7th stuff, but more cabined than he has. But and maybe, like I would have done the boat stuff and the June 7th stuff. I don't know about the rest of it. He's letting everything in. That's a perfectly defensible position. It will not, I guarantee you this now, if he is convicted, this will not lead to his conviction being overturned. Not going to happen. This is the judge did a great job because they did the mini trial, which is what happens. You know, some people asked, why didn't they handle this before the case? They filed something before the case. And the judge said, and this happens a lot in state court. The judge said, I want to see the evidence as it comes in, and then we'll decide. He takes the in-camera stuff where he actually hears from the witnesses. Then he makes a ruling. Then they have to do the witnesses all over again. And as he pointed out from the bench, yeah, it's annoying and it takes some time, but that's the law. I mean, that's how you do it. You hear the evidence and then you decide to let it in. He did a very good job hearing it presented. He heard the arguments from counsel. The arguments from the defense to keep it out were really bad. When you do 404, you also have to do 403. And 403 just says, even if it's 404B evidence and it's going to come in, it has to be more probative than it is unfairly prejudicial. And there's nothing really unfair about this. I mean, it's pretty prejudicial, but it's not unfairly prejudicial, and it's really probative. So it was always going to come in, I think, under 404 and 403.
To kind of show you guys how that weighing goes, the probative versus prejudicial, I think you're right here. In this instance, letting in the financial allegations of financial crimes, or at least his financial state, is not more prejudicial than probative for the murders. But let's say it were switched. Let's say he had not been convicted of murder, but he was on trial for a financial crime, just say for the $700,000, and the prosecution wanted to bring in the fact that $700,000 made him want to shoot and kill his family members. You can imagine that weighing of the risk of the probative and the prejudicial analysis there would be much different. So that's a way to think about it. In that instance, it would probably be way more prejudicial than it is probative of the financial crimes. But we're in the flipped situation, which is why I think that analysis weighs in favor of it being more probative than prejudicial.
And you see that a lot when you look at the cases where the courts will say things like, you know, you'd already been accused. Like I remember reading one in a case that I had where the guy was accused of traveling to a foreign country to have sex with 6-year-olds. And at the same time, they also tried him for some child pornography counts. And he claimed that the child pornography stuff coming in was unfair to him. And the court was like, look, there was already all this evidence coming in that you were traveling across the country to rape 6-year-olds. This wasn't that prejudicial to you compared to what you were actually charged with. And it's a similar thing. The financial stuff coming in is not that prejudicial. If it were flipped, it would be. And that's one of the things they consider.
And this might be jumping around a little, but trying to kind of keep up with y'all's very good comments here. So we've heard now that the judge is letting in everything. I really thought it was going to be a more split the baby sort of situation, but he's let in all the financial crimes. And one of you guys asked, is there ever a situation in which the prosecution wants to leave out 404 evidence? Well, the prosecution may have gotten more than it actually wants in this case. They have to make a decision of how to present all these financial crimes because the jury is already sitting there for a very long trial. It's already been going on for weeks. It's going to go on for much longer. And they are there for a murder trial. And so far, we have seen that the defense is not stipulating to any evidence, right? They are not stipulating to custodians who are necessary to lay the foundation to admit evidence. Typically, those are like the boring people who know nothing about the case, but they keep the records for, say, Sprint phones or, T-Mobile phone records. And they're there. They have to be there to lay the foundation to say, this is how we keep records. We produce these records and we know they're accurate because of this. And this is how you read the information. But they themselves know nothing about the case. There's a lot of that right now because they have to present the basis for the evidence, the admissibility of the evidence, and the defense will not stipulate it away. And we talk about that in our episodes, but it's a tactic to drag out the trial. With this very long trial already and a lot of it being boring by design by the defense, whether you want to bring in every bad financial act, and we know it's at least 100, if not many, many more, and bore the jury to tears, because there is such thing as beating a dead horse when you're talking about motive. Like, we get it. Like, whether it's $3 million or $3.5 million might not make that big of a difference, but it could bore the jury to death and they can lose sight of what you're talking about, which is the murder. So while the prosecution wanted in all the financial kind of misdeeds, the fact that they got it all, they have to be very strategic in how they choose to present it and how long it's going to take, because it can quickly snowball into a financial trial rather than a murder trial. And let me tell you, this murder trial is like as sexy as it gets. It's not like you need to bore the jurors or anything. There is so much to talk about with the murders.
And if you want proof of that, it was either yesterday or the day before that. For the second time, the financial person for the firm testified. Somebody who's known Murdaugh since they were in high school. Her brother-in-law is heading to federal prison because of his involvement with Murdaugh and some of this stuff. She really doesn't like him. And her testimony at times was incredibly powerful, particularly at the beginning. And when she was talking about that $700,000 and confronting him that day, and how after this all happened, it all fell away and nobody cared about it anymore, and all this great stuff. And then the prosecution spends hours going through every single check that Murdaugh ever stole. And at some point, I'm like,
that was a misstep, man. That was a misstep.
You're burying everything in this, and it's not, the jury gets it. They get it. He stole a bunch of money, and that's why you think he killed them. But by going through every single thing, you're actually weakening your point. And the jury's over there like, man, are we here for a fraud case? And we're doing a murder case, And so, yeah, I think, frankly, the prosecution's obsession with putting every single piece of evidence in is a mistake. And if they would have been better served if they had limited to this a little bit. They also would have been better served. Somebody is a lawyer in South Carolina. I would love to know the answer to this. Demonstratives are a wonderful thing. And I feel like if this prosecution had had a nice handy chart of every cell phone call. And they had used that to walk through, not every cell phone call, the ones that mattered. And they had used that to walk through with the witnesses or the checks that really mattered. That would have been so much more powerful than handing the person this like stack of papers and being, so turn to page 37, line 457, and this is 1430. What time is that again? 1432. That's military time. 232. And is this an outgoing or an ingoing call? Oh, this is outgoing. Okay, well, go back to line 30. It's like, oh my goodness, people, right?
By the way, that's when leading is okay. Like, get objected to, but just be like, did that call happen at 2:32 and was it outbound? And then let them object. You know, like there are times where you want to tell the story and move it along.
And they're not objecting to half the stuff anyway. I feel like you could lead. But anyways, I'm curious if in South Carolina demonstratives are disfavored because they're not using them and they would be so valuable. And you're just seeing that at all these places. So that is a very long way to answer the question of, yes, if you're the prosecution, you don't have to put on every single piece of evidence. One other thing I'll say, and then I'll shut up and let Alice talk. People keep saying, I can't see killing your child over X. I hope you can't see killing your child over anything. Putting yourself in the shoes of someone and trying to decide whether or not you would commit murder if you were in that circumstance is not the way to look at it. That is not what you need to do. You need to figure out whether or not this really was happening, he really was under all this pressure, and if there's all this evidence of him killing them, that might well have been his motive. And when you combine the motive to all the evidence and you put the two together, even if you couldn't see yourself doing that, which I sincerely hope you couldn't, that is a really good argument for murder.
Absolutely. And some of you guys have made that point, but like if a bunch of you were like, yep, could see why he would blow Paul's brains out, I'd be like, whoa, like our listenership is very different than I thought. And he is, I mean, there is a reason why he's on trial here, right? Like, thank goodness we do not live in a world where anything, I don't really care how bad it is. I don't care if it's millions of dollars or, you know, the ends of the earth that would cause you to do this to your own family. So I agree with you. This is inconceivable. And I'm glad it's inconceivable for most of you. It certainly is for me. But it's about him. It's about what's happening in his head. And that's why the prosecution rightfully gets to rebut who the character of Alex Murdaugh is. Because if they can't do that, they can't possibly show you why this person would choose to make this decision. And it is a reasonable doubt, right? It is a plausible action for him.
So, you know, a couple things on this, on what Alice was just saying. These kind of cases, motive's interesting. So the prosecution is putting on this evidence of motive. If you think the prosecution is dead wrong, that doesn't actually matter because you don't have to prove motive. Motive is not an element of the crime. So you can think he totally did it, but not for that reason, and absolutely find him guilty. If you're convinced beyond a reasonable doubt by all the evidence that he did it, you don't need to know why. The motive just sort of gives you more of the story. I mean, from my perspective, the motive is interesting. I think this is interesting. I think it gives a lot of color. It makes it more believable because I will be honest with you. The hardest part for me in all these cases is always that a parent would kill their children. Can't understand it. Blows my mind. Just can't even believe you would ever do it under any circumstances. I'd rather go to jail forever. I'd rather get the death penalty than have anything happen to my kids. So I can't understand it either, right? And that is sort of something that makes you wonder, like, why would you do this? But for me, the evidence itself is pretty powerful in this case. And people have asked about, do you always want to do this? There are times where you don't want to confuse the issue because what you don't want is for the jury to go back there and say, well, man, the evidence was pretty convincing, but then they put on all that motive stuff and man, I just don't buy the motive. And I feel like if I doubt the motive, that's reasonable doubt. And so I guess I can't convict. And that's a real danger that you have to be concerned with, particularly when your evidence is so strong. I think it is a danger worth doing here, both because I think people want a motive and because the defense has repeatedly said, why would he do this? And so you have to sort of answer that challenge if you're the prosecution and give a reason why he would do this.
All great points there, Brett. That's absolutely right. And that's why, guys, motive is an exception to the rule. If it were part of the case, if it were part of the elements, it would be in that book that Brett was just reading at the beginning. It would be in the elements. But for what he's charged for, motive is not an element that has to be proved beyond a reasonable doubt. Motive is... it's not a red herring. It's the reality that we are human beings who want to understand the world around us. You've heard us say this a million times. The best story wins. Hard to have a story without a motive, right? But that's not actually what you have to prove and what has to meet the standard of reasonable doubt. And someone just said something so perfect in the chat to show what 404B is about that I wanted to read what they said. This is what 404A and the B and C are trying to protect against. So I won't say your name, but this was a fantastic comment, and I agree with you in life. I'm not saying that you're wrong, but this is exactly how most people think and what these rules are made for. This comment says, when I learned he could cheat his own brother and his best friend out of money and totally manipulate them, I began to realize he was all about self-preservation so he could do anything. This person, what you said, I agree with you in life. That's how I choose who I associate with in my life. That's how I choose like what store I go to based on like these types of experiences, right? Like this weekend I had a terrible experience at a car dealership. I never wanted to go back there again. We'll never buy another car from them, ever. I don't even want to step inside to, use the bathroom if my bladder was about to explode. That is me using other acts to decide what I think about them for this particular act. 404 is trying to protect against this. And I only read that comment to take us back to what we're talking about here today, which is 404B. And that B, that it mentions motive, shows you that motive is not actually central to the case and not central to the determination of guilt. So talk all you want about how financial crimes and financial woes is not a good motive. That's okay. You don't have to believe that. The prosecution's doing the best they can to try and make sense of something that is senseless, but they recognize you have to tell a whole story, right? It's really dull to just go in there. But this is why the most important evidence in this entire case, and they focused on this, and I hope this is what they hone in on in the closing argument because it's so powerful, it's not financial crimes. It's not other stuff going on. It's not about what a good person or a bad person Alec is. It's the freaking cell phone data. It's the movements on each of their 3 phones and what's happening. That video, right before their phones go dark, that is so powerful because as Brett says, this is about whether he was the one to pull the trigger and kill his family.
No, I think that's 100% right. It's 100% right. And that doesn't mean that the 404B evidence shouldn't come in, but I do think it's important that the prosecution, once they have established this, and this is where I think they may be making a mistake, establish it and then move on. Establish that he did this and then move on and get back to the evidence of the case. And then wrap it all up at the end with the motive. Don't let it become all about the motive. To give you an example of when this wouldn't come in, just talking about the 404 stuff. Imagine, we all know he was on opioids. He had a drug dealer, just so happened to be the same guy who assassinated him or attempted to assassinate him on the side of the road. Imagine that he had gotten in an argument with his drug dealer and killed him. And that's what he was on trial for, killing his drug dealer. None of this financial stuff would come in. Because the only reason the financial stuff would come in is just to show he's a crook, he's the kind of person who commits crimes, and it's not surprising he would kill his drug dealer. Unless you could tie the financial crimes to the drug dealer's death, you couldn't do that. But here, there is a tie, there is a connection that's much stronger than in that sort of circumstance. And so there is no blanket rule about this. It is case by case. It is judge by judge. It's piece of evidence by piece of evidence about whether it comes in or whether it doesn't. Alice and I, we've tried cases where we tried to get 404B evidence in, and the judge just delayed ruling, and the trial was basically over, and he asked us, you still want to do this? And we've said no, because we're good. We're good. We don't want to mess this up. It is an appeal issue. Now, I have no doubt he will succeed, but if he is convicted, it will be appeal issue number 1 in their brief that this was the wrong ruling. And I think it will stand up to scrutiny, but it is an appeal issue they're going to have to deal with. So if you are in a situation where you don't feel like you need it, better to leave it on the cutting room floor than to continue to move forward with it. Somebody asked whether or not it was unusual for the Attorney General to do this. The reason for that is the local prosecutor has recused himself because everybody knows Alex Murdaugh, right? So he's recused himself, so you have to bring in somebody to do it. My understanding in South Carolina, it may be the case that whenever you have first-degree murder, the Attorney General gets involved. I don't know. That's a state-by-state thing. But certainly because the local prosecutor had recused, it's not surprising. A lot of times, AG's offices will step in when it's a small place. Like a big city, their DA's office handles murders all the time. No big deal. Small county where the prosecutor in this case is like an appointed volunteer prosecutor who's also got a civil practice on the side, who mostly handles DUIs and, petty theft, not ready to try a murder case, they will often ask the Attorney General's office to step in and handle it. So that may well be the kind of thing that would have happened here had they not had to recuse. Anyway, so not a big surprise. The death penalty is off the table. I mean, honestly, I think this should be controversial because it is hard for me to imagine a situation in which murdering your wife and child in cold blood and premeditation shouldn't justify the death penalty. If you're going to seek the death penalty for, somebody who robs a store and shoots the owner, I don't really know why you wouldn't do that here, but that was the decision of the Attorney General. Real bold, brave decision there by the Attorney General, but nevertheless, he decided he wasn't going to pursue it, so this is a life without parole case, and there won't be the death penalty on the table in this case.
I know you guys want to talk about the whole case, and there is a lot to talk about. But just know, we have started recording what I think will be, it might rival JonBenet in length, what this ultimately becomes, because we have no idea when the trial is going to end. And we are formulating our own theories. I don't know if we want to give it away quite yet, but there is a lot here. One thing to keep in mind, this is a slow-moving trial. The prosecution, I don't think, is near being able to rest its case. In other words, there's still a lot of evidence to come in. And remember, your evidence has to come in through witnesses. That's why you have to call the custodians to get in business records, right? One person can't get on the stand and just soliloquize and say, this is what happened, here's the story. That's the job of the attorney at the end for closing arguments. The reason is you get to cross-examine every witness and test their knowledge and the veracity and how much they actually know about what they are testifying to, and that is evidence. With all that said, the evidence is not all out yet. There's still evidence that we learn about every single day. So for those of you who are like, oh, there's no evidence of this, there's no evidence of that, we are not even halfway through the book, quote unquote. There's still so much more to go. And it is difficult when you have such a long trial. But remember, we are literally mid-sentence, so to speak, and there is much more to come.
Yeah, I get really tired of the talking heads who are like, well, the prosecution's losing. If the vote was taken today, he'd be not guilty. I mean, they're literally saying that on like the second day of trial. Yeah, obviously, that's the reason they're putting on all their evidence. It's like, well, today we heard from the custodian of records for Verizon, and I'm just not convinced that he's guilty. It's like...
And by the way, guys, there's a very good reason why jurors are not allowed to talk to anybody or read any coverage of a case. This case and any case, when you are handled on a jury, you're not allowed to discuss the case with your family, with your co-jurors. You're not supposed to read social media. You're not supposed to seek out any outside information about the case for this very reason, because it's incomplete. You haven't heard it all yet, so you're not even allowed to discuss it with the people sitting right next to you in the courtroom to say, well, what did you think about that testimony? Did you believe him? Because you are midway through. This is like a Wheel of Fortune board with most of the board still whited out. That's kind of what's happening. And that's why the jurors cannot discuss this case even with each other until the end of the entire trial.
So somebody asked whether or not good character evidence can come in. The answer is no. No. Prohibited use for character evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. So you can't say, well, they're a good person, so clearly they didn't kill anybody. Now, the thing about the rules is they barely apply to the defense. They're supposed to apply equally to the prosecution and the defense, but the fact of the matter is the defense gets away with a lot. And there are some character exceptions to that. We're not doing the 600 series of rules tonight, but eventually we're just going to go through every rule. We're going to start at rule 1 and work our way all the way through rule like 1200 or whatever it is. But
you know how people do like whatever in a year, like learn all your financial, disciplines in a year, and it's like a daily podcast, or like read the Bible in a year. Maybe we'll do like the criminal code in a year.
Alice, you keep comparing the criminal code to the Bible, and I just don't know.
I can't get over that you are literally flipping through the criminal code, which, guys, like, I've been hit in the head with one of those things. They're substantial. Don't ask me why I was hit in the head with one, but...
Yeah. Well, tonight my daughter picked it up and told me she was going to read it. I was like, good
and
luck.
she probably could, because she's very smart.
Well, look, we've been here for a while. What questions do you guys have before we sign off?
About 404. I'm going to have to limit it because I know you have lots of questions. And you will hear our takes on the case. We promise. It's in process. It'll be on the Prosecutor's podcast. Whereas at Legal Briefs, we're trying to discuss the different rules, things that are happening in court in real time for you guys so that you can make sense of what's happening, because honestly, the media gets it wrong a lot.
Yeah, if Jason will hurry up and edit it, we can go ahead and release it. So y'all need to talk to him.
Jason, don't let him bully you. Okay, someone asked, are you at all concerned with the extent of the 404B financial information getting in? No, this goes back to our previous question. I think it was right, and it's completely defensible. I may not have been so broad because I would be afraid of kind of having the longest trial of all time. And then it's up to the prosecution how they want to present it. So I'm not concerned about the appeal issue. I think it's defensible that the judge let in all of that financial information. Whether it is the best interest of the prosecution to go through it painstakingly, that's just a strategy question, and I don't think it would be in their best interest to do so.
And somebody asked whether the defense opened the door by mistake. No, they knew that as proven by those of you in the chat, they knew their best defense is, how could a father do this? And their hope is that people will think the financial motive's not enough, so therefore I don't think he's guilty. They know the danger. They know what they're having to do. That's the thing about being a lawyer. You're always assessing the risk of your approach and accepting the consequences that are going to come with it, because there's always a downside to basically everything you do. And they knew that, and they went into it with eyes open.
Absolutely. One last question. Okay, someone said the prosecution doesn't have to say this is the motive, correct? Well, when they argued for the 404, they made the argument that it was to show motive. I don't think they have to use those magic words to say it's motive, but what happens at the very end of trial is, in closing, you quite literally lay out the elements of the crime. You know, we do this in our episodes all the time. There's usually like 3 or 4. It's a multi-factor elements for the crime, and you have to find each of those factors beyond a reasonable doubt. They will go through those and emphasize what has to be found and what doesn't have to be found if they're doing a good job. And in that way, you'll know what the motive is. The storytelling will tell you the motive. So, but you don't have to make it explicit. I think that's the question. You know,
one other thing I want to address that we didn't spend a lot of time on. When you do 404, there's also the necessity that what you are introducing is essentially proven. You have to show by, I think it's clear and convincing evidence that this actually happened. So what you don't want to have speculative evidence coming in, and you don't want to have a mini trial to prove it. If it's something that there's like a real question about whether or not it happened, that shouldn't be coming in, and you shouldn't be having a trial within a trial to prove it. In this case, it is so obvious, it is so easy to show. He's already basically admitted to some of it. Very easy. Give you a counterexample. The Michael Peterson case. The death of Elizabeth Ratliff in Germany never should have come in, because that in of itself, whether or not he killed her, was completely speculative. You basically had to have, or would have needed to have, an entirely different trial with an entirely different jury to determine whether or not he was guilty of that murder before you brought it in. And even the judge, once the conviction was vacated, was like, I never should have let that in, and I never would let it in again. This is very different. This is not speculative. It's obvious. It obviously happened. So it's much more solid that this stuff is coming in, and that is not much of a problem.
Yeah, that's a great point, Brett. So that, in another way of saying that, is you don't have to be convicted of that crime in order for it to be able to come in. It's a different standard. So very likely, and he's already done it for some of the financial crimes, is he's pled guilty because the evidence is so heavily weighed against him. Okay, with all of that said, love all of your questions. We love that you guys are joining us on this. This is such an interesting case. I mean, this is really, it is the case for this year, and it's fascinating. We're following it to try and give you guys the most accurate information for you to be able to understand and make up your mind as to what happened. But remember, the trial's still going. Watch it. Send us your questions. We'll do another legal briefs on it. And remember to leave us your 5-star reviews if you like what you are hearing, to subscribe to Legal Briefs and to the Prosecutors Podcast, and find us on social media. We're everywhere: Twitter, Instagram, Facebook, a lot of places. And we like to keep you guessing as to who's actually commenting on the Gallery Facebook page, because that seems to be a constant topic of conversation. But before we sign off, Brett, do you have anything you'd like to add?
One free piece of advice to Alex Murdaugh and his lawyers is go find the local U.S. attorney and immediately plead guilty to all the federal crimes you can, so that eventually when you do start to serve time in prison, you can start in a federal prison and not state prison. Because while it's better to be convicted of a state crime because you might not serve any time, if you have to serve time, you want to serve it in federal prison. So he needs to take care of that as soon as possible. So that's my piece of advice to him, because I feel like this is not going well for him at this point. We'll see how it goes.
Indeed. Well, thank you guys for joining tonight and for listening. We love you guys. You keep us on our toes, and we only do these podcasts because we have the best listeners ever. So until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Okay. No, I'm not leaving. I'm sorry. We joked about that much too long. I'm not leaving. I mean, I'm not dead yet. Stay here. No, my news is... I'm sorry. I think the chat's like a little delayed, and it's really funny. I'm just curious, how many people are here? Like, how many people am I telling?
88.
I mean, I'm telling the
89.
world, but I legitimately thought there was a non-zero chance that I would go into labor during this recording tonight, and it's because I'm having a baby.
Well, I'm glad you didn't.
It was like a non-zero chance. I was like, I feel a little weird tonight.